There are basically three types of intellectual property rights that we work with in China: patents, trademarks, and copyright. Patents are used to protect original ideas, trademarks are used to protect brands, and copyright is used to protect original expression. And it's these intellectual property rights which provide your company with a monopoly over other companies. That is, you are able to prevent other companies from using your ideas, your brands, and your original expression. Well, essentially, any Canadian company that has operations in China will have some basis for using intellectual property rights. For example, if you're manufacturing in China, you have to be sure that you're not infringing other people's intellectual property rights. That is, somebody else's trademarks, somebody else's patents. That said, you could also prevent other people from using your brands and patents in China if you secure your rights here. Canadian companies will generally be well protected back in Canada. That is, they secure their trademarks, their patents, their copyright in Canada because that is where they are domiciled. But that being the case, if you are operating in China, those rights have no effect here. You're basically looking for securing your own intellectual property rights for China specifically so that you can operate free from interference in China, whether it's with your manufacture, your export of goods, or your sales of goods into China. There are a number of problems with the system. Although China has made significant progress with regards to the protection of intellectual property rights, the basis for securing intellectual property rights still suffers from some systemic issues. One item that is particularly troubling is the misappropriation of trademark rights. And that is, you'll have what we call trademark squatters, people who will file for other people's trademarks in China. And in doing so, by securing a trademark application right or a trademark registration, these trademark squatters will then approach the legitimate trademark owner and try to sell these trademarks back to them at an inflated price, of course, and in doing so, profit from using the Chinese intellectual property system. While there are recourses for a legitimate brand owner to recover the trademarks, they are limited, and sometimes they have no option except to pay the trademark squatter to buy back what is basically a trademark right that belongs to them. It's not uncommon to find trademark squatters who have filed for hundreds of trademarks belonging to foreign companies. Some famous cases that you might have come across or heard of is the Michael Jordan case, where another company is using the Chinese version of Michael Jordan's name. We also have other cases involving Apple, where there was a trademark which was misappropriated and sold back to Apple for, I believe, $46 million. So it's these type of cases that have garnered a lot of attention in China and has actually increased the profile or the incentive for people to misappropriate trademarks using the Chinese trademark system. And we see this problem also with domain names, where you'll have a party come into China, find out that somebody has registered their domain name using the .cn DNS or .com.cn. And for somebody who wants to start selling goods to the Chinese public using a .cn domain name, it comes as a surprise to them that, oh, somebody else has already registered my domain name in China, and therefore the only way I can recover this is either I go to dispute resolution and arbitration with the CNNIC, which is responsible for the .cn domain name, or they pay the domain name squatter to recover these rights. And essentially, this can all be avoided if a Canadian company just takes one step: be proactive. Canadian companies have to be proactive in terms of securing their intellectual property rights in China. If you have brands, file to register them in China. They cannot take that wait and see approach where perhaps maybe in 5 years we'll see how well we're doing in China before we commit to the cost of securing intellectual property rights. By the time they end up trying to secure the rights in China, they found that somebody else has already applied for their trademarks or have filed for patent protection for some of their inventions. And doing so, they've lost their rights. And the worst case scenario is that a competitor secures these rights and then they're able to operate in China under your brand or with your patents, with your copyright. China is essentially, it's the manufacturing center for the world. And that said, if you do not secure your intellectual property rights in China, this could basically prevent you from manufacturing in China. And that means you will not have the benefits or the cost savings associated with having your manufacturing offshore in China. So if you're selling goods that are made in China around the world, for example, you're selling to Europe, Australia, the United States, or Canada, of course, but if you're manufacturing in China, if your trademarks have been misappropriated, these goods then might be seized at China customs so that they cannot leave the country. Therefore, you will miss your orders, and this exposes you to other types of liability that you might not have anticipated by losing your intellectual property rights in China. Take, for example, that you have a specific brand for Canada and somebody else has registered your trademark in China. Basically, this other person who has registered your trademark in China could then stop this company from manufacturing your products. If you're importing back into Canada, essentially your entire supply chain is going to be disrupted. And that said, you will not be able to deliver your orders in a timely fashion, and this will bring up other issues and potential liabilities to your customers around the world if you fail to deliver on time. The one thing that I would stress more than anything else for Canadian companies is that you have to secure your intellectual property rights for China. China is now the second largest market in the world, only behind the United States. And I do not think it's a matter of if a Canadian company will come to China, it's a matter of when. And when I talk about coming to China, it's not just about coming to the Chinese market to sell here, it's manufacturing here, it's exporting here, it's outsourcing creation, design, research and development. And once you have any business association with China, you need to have your intellectual property rights in place, because if you do not, whatever carefully laid out plans you might have involving China could be derailed.